Hi there, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And today I am very excited to have with us attorney Nicole Reeves Lavallee. She owns a family law firm out of Worcester, and she's been on the show many times. Today we are going to talk about something very interesting. We're talking about restraining and harassment orders. Welcome to the show today, Nicole. We're so happy to see you.
Thank you for having me, and hopefully we can learn something again this week.
Absolutely. So let's just talk about a definition of harassment and restraining orders so that the people that maybe have heard it but don't quite know, might have the wrong idea, can get this cleared up.
So a harassment order is going to come in play basically when you can't get a restraining order. So restraining orders come into place when it's either a family member that you're seeking to get an order against, or if you had a dating relationship with them. So something of that nature. So you have to have a significant relationship with this person that's just not a friend. Some kind of family relationship, or again, that sexual relationship or that dating relationship. And that is going to come into place when you're in fear of imminent bodily harm. So somebody has threatened you, somebody has hurt you in any way, that's when it's going to come into play. A harassment order, you don't need the requirement of any family member. It could be a neighbor. It could be a friend of yours that you've obviously never dated, something of that nature. And what that requires is for somebody to come into a situation and say, stop. And you have to say stop at least 3 occasions. Doesn't have to be in writing, although writing is much better for us. But it has to tell you to stop harassing me. I don't want to have these phone calls. I want you to leave me alone. And if that happens on more than 3 occasions, you can go into court and get an order. So once you obtain the restraining order, the restrictions and the language in any of the orders are almost identical. So it's certainly something to take a look at, and you can figure out what you need to do, but you have to meet the standard as to which one when you're going to proceed for that legal action.
I see. So that's good to know the difference between those two. When should you get one of these orders?
Biggest thing is you should get it when you need one. So again, harassment order, kind of very simple. Again, I've told this person multiple times, they just won't leave me alone. They don't take no for an answer. I don't really like this person and I don't want them dating me anymore, and I don't want to be in this situation, whatever the case may be. So something very simple like that. A lot of times it could be neighbor disputes where, you're just at each other's throats and you don't want to be in that situation. So that's a great thing for harassment order. In a restraining order, it's a higher standard. It has to be imminent fear of bodily harm. So there has to be something. It could be an overt act. So it could be somebody going like this to you. It could be them saying, I wish you were dead. I'm going to see you in the grave, something to that effect. So it certainly is more overt in terms of what it is that they're doing. And again, anything can be imminent fear of bodily harm. Sometimes people overreact, and that's something that the judge is going to consider. But again, what does that look like really depends on the circumstances and how you can lay it out. And I think if you have a history of, hey, look, I've been in this relationship for 5 years, and my spouse, my boyfriend, is a control freak. Every time I do something or I want to go out with my girlfriends, he starts threatening me. He's punched holes in the walls, things of that nature. Obviously, the more you can articulate, the more the judge is going to be inclined to order a restraining order.
I mean, those sound like some very scary situations, and I'm sure that you've heard your fair share, unfortunately, of these situations where someone would actually need one of these orders. So, I mean, one would think if you had a restraining or a harassment order out against somebody, that it might help in your divorce and custody case. Is that true?
Really hard question to answer. So one of those things is you really have to use it as a shield, not as a sword. So it's not, I'm going to get custody, so I'm going to get this restraining order, ha 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 ha, and now I've gotten custody under the restraining order. So it all depends on the motives. It all depends on what's going to end up happening. So certainly if you are in that situation, absolutely go and obtain a restraining order, no matter what. You can get them 24/7. That's the good thing. It's not that you have to go into court. You can get them by the police at the middle of the night. There's always an on-call police officer that will call the judge that's on duty to answer the questions to determine whether or not a restraining order or a harassment order will issue. So you do have that benefit of a 24/7. But if you need it, use it. But if you don't need it, don't use it as just a means to gain leverage in your case.
I mean, I think that that goes to what you always say is that it really, what comes around goes around, and you want to make sure that you are being fair during your divorce case. And so I can see what you're saying there. If you're just trying to be underhanded and sneaky, the judge picks up on that.
Not only does the judge pick up on it, but again, you're going to most likely see this judge multiple times. They're going to get a sense for you. And if the judge thinks that you're lying about one thing, maybe it is a restraining order, maybe it's something else, the problem is that that's going to come back and bite you. So it is going to be in your best interest, to be honest. And yes, I do reiterate it because I think it's important. I think everyone needs to hear it. Unfortunately, probably every time I talk, they need to hear it because at some point it needs to sink in with people, because it's not going to be to your benefit to do this if there's really no grounds for it.
Well, I mean, I think it's great. And you know what? Sometimes people need reminding because they're in the middle of this terrible situation in their life and emotions get the best of them. And even under normal circumstances, they may not be a mean-spirited person that's trying to get back at them. But this person that they're divorcing is just push them to the limit, and so now they're using every means possible, but they have you to reel them back in and keep the voice of sanity and reason in their heads, which is great. I do have one follow-up question. If you do get one of these orders, harassment order, can your children be under that as well, or how do they usually work that?
Generally speaking, you're not going to get a harassment order against somebody that you have children with. It's probably going to be that restraining order. And yes, the answer is yes, the children can be included in both of them. Obviously, if it's just a neighbor or friend, then you'd want to have that child in there and protected because there's no reason that they need to talk to the child. In a restraining order situation, the child will be included almost initially if you're the custodial parent. If you're not the custodial parent, then that might not apply. But there are going to be restrictions on that. So it's certainly something to be aware of. And you can articulate to the judge what it is that you want and how it's going to best serve you and your family.
So if I had a restraining order against me and it stays in place after the divorce, does that mean I don't get to see my children ever?
Well, let me back up. Restraining orders aren't going to necessarily stay in place throughout the entire divorce. So a restraining order is going to be reviewed after the first hearing within 10 days. So if your husband decided to get a restraining order against you, then he'd have to come back into court in 10 days. You'd have an opportunity to be heard on that. And then if the restraining order continues in place at that point in time, you would want to make an argument to the judge that says, hey, can I have some parenting time with my child? And the judge would either allow it or not. And they may allow it in a supervisory position or unsupervised, depending on what arguments are made by the parties. And then the judge would also give you a return date as to when that restraining order expires. So generally, if we see it in probate court and we know that there's a divorce pending, what the judge is going to do is push it out 2 to 3 months. They want the parties to calm down, try to get over the emotional state of a divorce, and then hopefully they'll be on a better track so that they can, tend to co-parent. If that really continues or somebody is really belligerent, then obviously that could extend well past the divorce.
So you kind of answered a question that I had coming up, but I want to see if you want to expound on it. How long do these orders typically last? I know you said initially 10 days. and then they revisit it. Is there more to it?
There is. So obviously, that would be the first period is always going to be within 10 days so that we can give the other party notice of the hearing. After that, the judge has the right to extend it out to up to 1 year. So again, they're going to look at the circumstances, say, is it warranted for a year? Is it warranted for 2 or 3 months? And they'll extend it out for up to a maximum of a year. After that year, you'd have to come back and renew it and say, again, I'm still in imminent fear. This is what's going on. And the judge would again make a ruling as to what time frame, if any, that they're going to extend it, again, up to that 1 year mark. At some point, you can make it a permanent order, which really means permanent. However, the courts really are not inclined to do that. Maybe after the third or fourth year of you coming back, then they would consider a permanent order. Or obviously, if there was conviction charges where the person that has the restraining order against them was convicted of assault and battery of you, something like that, then that would be grounds for a permanent order.
So what's the process to get one of these orders?
So essentially, it kind of depends on what's happening in the world. But again, if it is during the day, then you can obviously go into the courthouse. You can do that even now, or you can file it online and submit it to the court. Basically, it's a really long application, but it's an application because they need to know what's going on. They need to know what your information is, what your exes or whoever that information is. They need to know social security numbers, date of births, birthmarks, addresses, work addresses. I mean, they just go on and on. So a lot of that is just informational purposes that they're going to put in a computer system. The other part of that is obviously your affidavit. So if you can fill out your affidavit beforehand and have it typed up, then obviously that's much easier because one, the court can read it, and it's not scribble handwriting. And two, obviously you can articulate exactly what it is you want after you think about it. So it's not just you scribbling it out and going, oh, I really wanted to add this in. Let me find a spot. And then, it kind of makes it a little jumbled for the court. So after they submit all of that documentation, then the clerk will run both of your queries, which is your criminal record. They will run both of them. They will submit everything, docket it. You will get a file, and then you will be sent into the courtroom. Once you're into the courtroom, then you'll have to present the exact same thing that's listed on your affidavit and maybe more questions as to what specifically led you to come here today. Why do you need the restraining order? And the judge will ask you various questions. Now, obviously, if it's after hours or we're in a state where the court is no longer open, then again, it's going to be happening by the police officer getting a judge on the phone or the judge having a hearing telephonically or by Zoom so that we can have that exact same situation, knowing all of the facts, finding out what's going on. And then again, we go back to if it's issued, we have a 10-day return hearing.
I see. So that's quite a process. So I'm going to take the time right now to say if anybody has an issue, you need a restraining order, you need a harassment order, you need to just ask some questions, please pick up the phone and call Nicole and her team, because as you just heard, the process can be kind of complicated, and you want to make sure that you state your case clearly, especially if you're the one who feels like they're in danger. But conversely, on the other side, there might be some false accusations going on, and you may need protection in that area too. And with that, my next question is, if somebody does get a restraining order out against you, does it go in your criminal record?
It goes on a carry report, which is part of your criminal record. So it does go on there. It is not obviously criminal charges at that point. So it is something that can affect you. A lot of my clients that have government jobs or even a police officer, something of that nature, that will affect their job. Teachers, it will affect your job. So again, it's kind of something else that, again, you do not want to use this as a sword, because if you are and your spouse is a teacher or a police officer, guess what? They may lose their job, which means you're not going to get child support. So yes, you might get the child, but at the end of the day, they're going to be suffering, the child's going to be suffering, you're going to be suffering. So again, think about your actions. But there are certainly actions or jobs out there that will affect it a lot of times people don't necessarily care. Me as an employer, I'm not going to necessarily care about it, but might ask for an explanation. Why is this here? And so again, does it coincide with the filing of a complaint for divorce? If it does, then I probably know the answer to that. So again, we can kind of weed through a lot of it, but there are certain jobs that you can and you will lose your employment as a result.
So what's the standard?
The standard, again, is going back to, is it imminent fear of bodily harm? Is there something going on? And again, I can't reiterate this enough, because people will say, well, 6 months ago they said this. That's not imminent. Again, and maybe if there's a history and it's a repeated thing and it happens on a daily basis, something to that effect, okay. But when you're writing that affidavit and when you're telling the court, they need to know that this is now. So yes, it's great to keep a log. Yes, it's great to have all that information and present it to the judge. But most importantly, what is happening at this moment is what is going to be crucial to your case. That's why the judge is going to determine if it's a yes or a no. So really point those facts. If you have, a text message, if you have a voicemail, show that to the judge. Let them hear that. Those are the things that are going to sway them.
Okay, that's really good. So what are the restrictions, if any?
So a couple things restriction wise. So obviously the restrictions are going to be that you have to follow whatever the restraining order, harassment order says. Generally speaking, it's going to be stay away from that person up to a certain yardage. The standard is going to be 100 yards. It is also going to say that you cannot have contact with them. Now, obviously that caveat may change if you have children and you've amended it so that you can talk to your ex about the children. But it may be very limited that says only talk to the ex about the children and not everything else. Not, we want to sell the house. That would be a violation. So there's going to be those types of restrictions. The person that has a restraining order against them is going to lose any right to firearms. So all of their FID or their license to carry cards are going to be revoked, and any guns or weapons that they have are also going to be seized and they're going to be placed in police custody. So those are the general restrictions. Obviously, the other restrictions can be is that you're not going to be permitted to go to the children's dance recitals or talk to the children, or go to your spouse's work of employment, things of that nature. And obviously that's going to be as specific as the victim wants it to be.
So do they get the guns back later? Or I'm just curious, because I think there's probably some Second Amendment people out there that might be curious.
It all depends. I've had cases where there has been a restraining order and a small town in central Massachusetts said, no, we're not going to give it back, even though after the 10 days, it was found that the restraining order shouldn't have remained in place. Because of the standard, they said, we're not going to allow it. And it was really sad, because all he really wanted it for was hunting. It wasn't a license to carry. It was simply just for sport. But they took it back and they would never give it back to him. Other towns say, we'll give it back to you after the restraining order has expired. So again, really town specific. And most importantly, is there other criminal charges associated with it? If it's not only a restraining order, but assault and battery or attempt to murder or something like that, then chances are you're not getting it back. But again, we have to look at the big picture as to what other things have happened that would warrant it being taken or seized. And then you do have a right to appeal that, but I don't do that. And I know that the client that really wanted it back in the small town never got it back, even after hiring an attorney to do that.
So what would the benefit be of having a restraining or a harassment order?
The benefit is peace of mind. I think that's your biggest thing. I mean, everyone looks at it and go, yes, it's a piece of paper. I get it's a piece of paper. And I get that that piece of paper can't necessarily prevent the crazy person from coming into your house in the middle of the night and murdering you. I get it. But we can't think that way, because if you think that way, you're going to ground yourself and believe that, and you're not going to be able to move forward to obtain that restraining order. You have to know that there are services out there. They drive by your house. You pick up the phone and you call the police and they say, you violated the order, get over here, I want him arrested. So it's that extreme that you can do that. They send you a text message, that's a violation. They do any of these things that are in violation of the restraining order, they're going to have criminal charges against them. And again, restraining order not necessarily criminal in nature, but tack it on with a violation of the restraining order, that is criminal. That will automatically go on your criminal record. So it's just something to be aware of, that it does have teeth. So if something is happening, you need to reach out. You need to tell the proper authorities. Call the police in the middle of the night. I don't care. Call your attorney who will tell you to call the police. But those are the things that can help you. And obviously, it's a piece of paper that has teeth. So use it for that advantage. Use it to make sure that you're in a safe environment. One of the things you can do is have your address impounded. So if you move, then obviously it's protected there. If you happen to be walking into a grocery store and your ex that has a restraining order against him walks in, he's got to turn around and walk out. If he doesn't, he's violating the restraining order. So again, these are all things that can absolutely help you to kind of get peace of mind, that this person is not going to harass you, this person is not going to control you, this person does not have any ability over you at this point in time. You are a strong person and you can overcome this. And that's the very first step in any kind of domestic dispute.
Well, this has been very helpful, and you are very passionate about this topic. I can tell that you've had to help a lot of people in this area, especially what your specialty is in family court and divorces, custody, everything that has to do with family cases. So this is all fantastic information. I hope that this information has helped some of the viewers today. And again, I just love to remind you to pick up the phone, give Nicole and her staff a call. They are very knowledgeable. They can give you strategies and options, and most importantly, peace of mind. Thanks so much for joining us again today, Nicole.
Thank you. And I just want to say one more thing here, is that you do need to pick up that phone, because you know what? If you are suffering through domestic violence, the easiest way for you to do it is to pick up the phone, have a consult with us. We can walk you through it. We can tell you exactly what you need to do so that you're out of that situation and you're in a better environment thereafter.
Absolutely. Thank you, everybody, for watching.